this is one of my probably many heretical views, but I think that people oversell confidentiality in mediation and collaborative law. You can, and the problem is that the independently discoverable evidence is introducible, is admissible in court. So if we're in a mediation or a collaborative process and you tell me that you've hidden some assets in a Swiss bank account, I can't, put you on the witness stand and say, isn't it true, Kim, that you said in the mediation or the collaborative process that you hid this, that you have this secret bank account. But I know where to look, and it affects the negotiation dynamic. So although I think that there is a value to having some confidentiality, I think people place more reliance on it than I think is appropriate. And actually, in some ways, I think, when I look at the way lawyers mediate, they're often very careful, particularly in the civil mediations, careful about making disclosures to the other side, even to the mediator. And in terms of the cooperative process, I think you can make agreements about what's admissible or not, and really not much different. I mean, if you have just the fact that you don't have the collaborative lawyer being the one who is there, if you have a collaborative process that ends and then they litigate, the party has the information and presumably the documents, which they can then give to their litigation attorney. So I don't really see that as a practical matter. The disclosure of information issue is a big distinction between collaborative or cooperative, and in some ways it may be somewhat more straightforward in that people may have a false sense of security, of safety in this container in the collaborative process, and similarly in mediation that isn't really appropriate. I think a lot of it is really psychological and emotional, and not really, if you look at the practical implications of how confidentiality would really work with disclosure of information. Distinguishing between the big C and the small c. Small c is cooperative as an adjective. We're friendly, reasonable lawyers, and we, have a case, and we're going to, exchange information and see if we can negotiate. Big C cooperative is where there's an agreement, there's a structured, planned process. The Wisconsin folks do it often with an oral agreement. They have a brief statement of principles that sort of is incorporated by reference orally. Personally, my preference would be to have a written agreement, much like a collaborative participation agreement. And in fact, I helped a group in Mid-Missouri, the Mid-Missouri Collaborative and Cooperative Law Association, which has a wonderful website and some forums, and it has a participation agreement for both collaborative and cooperative, and they're almost identical. Obviously, the cooperative doesn't have the disqualification agreement, and there are other very minor changes. So the same sort of thing, there's a commitment to full disclosure. One of the interesting things that came out, and this may be a footnote that we may or may not want to pursue in my study of the Wisconsin lawyers, was sort of what the definition of relevant information is. What I found was that there were a range of opinions about, I did a survey and I had them consider a range of hypothetical situations, and I asked whether they felt that they had a duty to disclose, whether they had no duty to disclose, and that they would not recommend to their client that they disclose it, or that they had no duty but they would recommend. And in most of the situations, and of course I was looking for things that were somewhat ambiguous, and people had a wide range of opinions. My guess is that if we did a survey of many collaborative lawyers, you'd probably have a similar range, although I haven't done that study and I don't know. From the conversations that I have had and heard with people, that would be my sense of collaborative lawyers in terms of what they would define as relevant or not. That to me is a more interesting one in terms of problem, which is true for all of these processes, both collaborative and cooperative, in terms of what you really do need to disclose or not. Because obviously there's some things that are not relevant and you wouldn't advise your client to disclose. It's a really important issue. One of the things that I advise, I think that there's kind of a local practice culture, and I think that people ought to have their local CLEs and say, let's do a bunch of hypos here, is relevant or not? and then have a discussion, and then develop some more explicit group norms about that. So, I mean, that's my thought about that, and I think that this really does vary from one local culture to another, one community within a given state, let alone from one state to another. David Hoffman wrote a wonderful article identifying a series of barriers to why collaborative law is going to be very hard to use in business or non-family cases. And basically, I would just, I think his article is persuasive. One of the things is, if you look at divorce cases, you have, lawyers have a portfolio of a relatively large number of small cases where they don't particularly have an interest in having repeat business. When you have other kinds of cases, lawyers have a portfolio, particularly if you have commercial cases, I mean, where you have a smaller number of large cases. So if you have ongoing relationships between the lawyer and the client, I think a lot of the collaborative lawyers don't appreciate that both the lawyer and the client really value the lawyer-client relationship, and I think a lot of them say, oh, no big deal, you can replace a lawyer, just hire another one, as if they're kind of fungible products you can plug in and plug out. I think that in lots of other contexts outside the family context, lawyers and clients don't feel that way. From the lawyer's perspective, if you have a civil case and you go into a collaborative process, you negotiate, doesn't work, and then the client goes to litigate, what are they going to do? They're going to go to a competitor down the street, make a lot more money in that litigation case that they otherwise might have made, and then there's the fear that that client will go back to that other firm for other matters. So, I mean, there's just a huge risk there. And then from the client's perspective, part of what I think a lot of clients who have ongoing business, legal issues, is that they want to have lawyers who know them and who know their business or their activities, and the idea of starting up new with another lawyer is a real problem. So I think that the disqualification agreement is a real barrier for lots of them, and I think that actually a cooperative process where they don't have to discard their lawyer would be attractive for some of the non-family. I did a CLE for some elder lawyers and about cooperative practice, and one of them was saying, and actually several of them were talking about how they've had relationships with their clients for 20 years, and the idea that they're going to get in dispute and then they might be disqualified and couldn't continue to represent them, it didn't compute. So it works well for those kind of cases where there isn't a value for ongoing relationships, and so I mean that's why I think God bless the civil collaborative folks and to try and get that to work. I could imagine some small business, some probate. Interestingly, I mean, I know there's been a tremendous amount of effort in Cincinnati and Boston. I know others have really tried to do it in probate, and as far as I know, what I keep on, I mean, there's only been a handful of cases. David Hoffman, put out a query on a listserv. Have you ever had a civil collaborative where you've actually signed a participation agreement with the disqualification agreement? And only a handful, this a couple of years ago, he could only identify 8 cases. There are a lot of people said, well, essentially we've done it collaboratively, small c collaborative, which is in effect like a cooperative process. A lot of the collaborative lawyers are so committed to this ideology of the disqualification and how important it is that trumps, that they're not willing to acknowledge that this is a useful alternative and that they're still so committed to it. And again, I think it's terrific for folks to try and to offer it, and if parties are willing to use it in these other kinds of cases, that's great. For the reasons that I've described and others that are in David's article, I just think that it's not likely to be anywhere near the growth industry that the divorce, collaborative divorce is.